first to know Nsem-Pii TV.
Lawyer Paul Admoch ni trans na ensema ekoso. NDC for say edie na ebo musu say edie na siu. Kame say omuhu do munye. Eye Attorney General Godfrey Odame emra Dafeamekpor ede case ni court no pe or the koyen say MPs I appoint as hot ministers nya dia obepene preko peno na omo expect say omo there LGBT plus Q plus no case ni say diwi ansana omo tena sa case so eno na yewura Godfrey Odame kire say oye intelligent oye very smart or try letter the command the Chief Justice of the Ghana say na ekoso ti dia dure die wa anya Ghana ye be just standstill come ministers as of running nation no na Paul Admoch say let be a NDC for them out okay na ra kusem ase emeranimfo ni ho enso mo cha chiketa ne aditirifo na wo kan letter na ye wura Paul Admoch echechim say we dey over the bar anhye nkran na enhye enmunyam nti emra o chirichirim no say Dafeamekpor wa nya ade we die company go tie die ko so o say dey menko etiefo you couldn't go to Paul Admoch Nsem or the two.
Have a look. So what happened? On the back of the LGBT bill, Parliament had sent a bill to the president, and on the back of that, Parliament had concluded its work on a bill. First reading, second reading, third reading, consideration stage. All of that had been done and completed. The bill was now ready to head for the president for his assent or refusal to assent, and then we can determine whether it becomes law or the process continues. Under the law, if the president refuses to assent a bill, 2/3 the bill returns to Parliament. The president will return the bill to Parliament, and 2/3 of Parliament can vote and establish the law. If Parliament is not able to marshal the 2/3, the bill naturally dies. You can have some court processes in there if the president's refusal is not backed by law, it's not backed by a constitution. It is only whims and caprices. Even if the president argues that is by his discretion, you can go to Article 296, which regulates the use of discretion by public authorities. So that's the process of a bill. Now, before the Parliament could send the bill to His Excellency the President, Richard Delasky of City FM and barrister at law, solicitor of the Supreme Court of Ghana, filed an application at the Supreme Court indicating that there were aspects of the bill that violated the rights guaranteed Ghanaians in the 1992 Constitution. Now, he also added an interlocutory injunction, didn't he? And Mr. President, a letter from the Attorney General to the President informing the President that there's a legal action pending against this bill that is coming to you to sign. So please consider it and hold on until the Supreme Court decision. Mr. President then caused the letter to be written by his secretary to Parliament, which created some hula baloo based on the according to the concerns, the words that were used by the president's secretary, etc., all of that. But the letter did go to the speaker and the clerk, and it was received. It was a letter that was indicating to Parliament that the Attorney General has so communicated to the president, and therefore Parliament should hold on from presenting the bill to His Excellency the President. Okay. When Mr. Speaker received that letter, days after or a day after, he was sitting in the chair when Parliament had to consider the vetting of ministers that had, the president had done some cabinet reshuffle. So there was a vetting process going on, including Abena Osei, the Honorable Deputy Minister of Finance, who has been made Deputy Minister of State, including Lawyer Japan Mesa, MP for Secondary, who was Deputy Minister at Energy, now been appointed Minister for Tourism, and all of that. Dafeamekpor brought out a writ to say that in the president's communication to Parliament, he said he had terminated some appointments of ministers and reassigned them. And he's saying that the president cannot terminate and reassign without they going through Parliament. It's the age-old practice where if a minister is reshuffled from one ministry to the other, so long as he's appointed at 78, there's no more vetting. Dafeamekpor is challenging that on the basis that the president said he had terminated appointments. So all of that is going on. This is not the real, so I'm now coming to the story. And then Dafeamekpor goes to court and says, I want the Supreme Court to declare that those ministers that the president said the appointment have been terminated, he cannot reassign them. And then he brings an interlocutory injunction against that. He files it. Speaker has notice of it. The speaker then decides that because of Dafeamekpor's writ, he is not even going to deal with anything about ministers. This is where we are. Okay. So the injunction, yes, The injunction of Roxanne Dafeamekpor is pending before a court. As a result of that, Speaker says, I will stop any other proceedings, related or unrelated, I will stop. Many lawyers take the view that the Speaker is wrong in stopping the process of ministers appointed at 78. We took that view as well, but it doesn't matter. Speaker has stopped it. All right. Now, Dafeamekpor's writ is in court, injunction, but there's no dates to argue the injunction. So, can I have the photographs, please? So, the Attorney General then decides to what's happening? I want the two photographs, the same one I was dealing with, please. The Attorney General then decides that he is going to make sure that this case is heard, because it's important for Ghana. Ministers are not ready. They are hanging in there. There's some sort of blockade to doing their work, taking their oath and getting their work done. The country is running at 8 months to election. Very soon there will be the election will be here. People may not have time, so the government business must run. So the Attorney General writes a letter to the Chief Justice and says that, Madam Chief Justice, this interlocutory injunction of Dafeamekpor, which has no date, is not helpful, because we need to sit down and hear the matter and move on, because government business is suffering. By what process did the Attorney General make this communication? The Attorney General has told the General Public, he wrote a letter. We have the letter here, we'll show it to you, that he wrote a letter to the Lord Chief Justice. Now, this letter is what is created, telling them that it is not the way that they are interpreting it. That's not what it is. We'll get the details here. Okay, let's move to what happened when the Attorney General's letter was written. So the Attorney General's letter was written, the Chief Justice agreed, obliged, and set a panel to hear the matter. The panel then the Speaker and to Roxanne Dafeamekpor's lawyers that, look, the matter that has been filed by Roxanne Dafeamekpor without a date for hearing, we now have a date for hearing. It is on so and so 26th of March, blah blah blah, 2024. And so, Leonard Attorney General, please be in court. Honorable Speaker, Right Honorable, please be in court. Roxanne Dafeamekpor, please be in court. When the bailiff went to Roxanne Dafeamekpor's office to serve them with a hearing notice, which they may have heard about, they refused to hear it. They said they are not interested. They will not come to court. This is a case that he is prosecuting, and there's no date, and the date has now come. He says, I'm not interested in prosecuting the matter. I will not show up in court. Well, people should ask him why. You go to court, you are suing somebody. There's no date. The person you are suing says that, look, me, I need to hear this matter quickly so that I get up, because I know you have no basis on this. Let's go to court. Court date is set. He doesn't show up. He says, I don't want to be there. In any case, the court does their work. He doesn't show up. The Speaker argues against his injunction. The Attorney General argues against his injunction, and that's very important. The Speaker's lawyer for the Speaker, argued against the Dafeamekpor's injunction. The Attorney General argued against the injunction, and then the court grants it. Who are the members of the panel who granted it? Let's get the panel. Please, let's do it very quickly here. They are going to get us the names of the panel, the members who were on the panel. Okay, so is that it? All right, yes. So it was led by the Lord Chief Justice, Justice Tokonu. She sat on the panel. Thank you, Madam, that you did. And then I believe this is Justice Kumsin, I think. He also was on the panel. This is Justice Amadou Tanko. And then this is Justice Mariama Owusu, I believe. She was also on the panel. And this is Justice Yao. I'll get the name. He was also on the panel. So 1, 2, 3, 4, 5 Supreme Court judges met and completely dismissed Dafeamekpor's matter. Okay. Soon after the dismissal of the Dafeamekpor matter, the NDC issued a statement. Let's get to the NDC statement. The NDC issued a statement complaining about something. Let's have it. Let's have the NDC statement. It's going to come on the screen in a little bit. Okay. Yes. So this is the NDC statement. It's entitled, NDC reacts to palpable judicial bias in the settling of political cases in the Supreme Court. And it's as follows. It says, the National Democratic Congress, NDC, has become aware of the decision by the Chief Justice of Ghana to list the case of Roxanne Nelson H.A.K. Dafeamekpor versus the Speaker of Parliament and the Attorney General for hearing on Wednesday, 27th March 2024. The NDC is intrigued ahead of the case of Richard Delasky versus Parliament of Ghana and the Attorney General. It is interesting to note, the statement says, that Richard Delaskai filed his writ of summons in the Supreme Court challenging the constitutionality of the Sexual Rights and Family Values Bill 2024 on the 5th of March. This was almost 2 weeks clear before Fiifi Dafeamekpor filed his writ of summons 2024 challenging the constitutionality of the latest ministerial nomination by the president. Given the recent political deadlock that these two legal suits have created between the executive arm and the legislative arm of government, one would have expected that the date of the filing of the cases of the hearing by the Apex Court. Yet, for some strange reasons, the statement says, the Honorable Fiifi Dafeamekpor, which was last in time to be filed, has been hurriedly listed for hearing tomorrow, whilst that of Richard Delaskai, which predated the Dafeamekpor case by 2 weeks, has not been listed for hearing at all. This is in spite of the fact that no application for abridgment of time has been filed by any of the parties in the Dafeamekpor case. It's quite apparent that this is a ploy by the Chief Justice to fast-track the determination of the suit by the Honorable Fiifi Dafeamekpor. They call it a ploy. So it's not very, it's language that alleges too much against the Chief Justice, but that's what they say. So this is a ploy by the Chief Justice to fast-track the determination of the suit filed by Fiifi Dafeamekpor, while the determination of the Richard Delaskai suit is deliberately and unduly delayed to enable the president shelve the crucial Sexual Rights and Family Values Bill that has been passed by Parliament. Even more bizarre is the fact that the case filed by the NDC members of Parliament challenging the constitutionality of the passage of the Electronic Transfer e-Levy Bill as far back as 2022 has not been listed for hearing. The arbitrary exercise of administrative indiscretion by the Chief Justice, particularly in the shelling of cases in the Supreme Court, goes to fortify the high perception of bias on the part of the judiciary. Such judicial manipulations go to confirm the growing public perception that the current Chief Justice is a blind accomplice and abettor of the misrule of the despotic Akufo-Addo. Wow. These are very, very, very harsh words. That the Chief Justice is an abettor. Whoa. While the Constitution of Ghana vests discretionary power in the Chief Justice in the discharge of her administrative duties, it is important that such discretionary powers are not exercised arbitrarily, capriciously, and whimsically. Judicial independence must mean exactly that. At no point should the judiciary act in a manner that lends itself to the grounded belief that it is willing to aid in an overbearing executive in a standoff with the legislature. Chief Justice must appreciate blah 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 the listing of cases. Okay, so all of that is published by the NDC and is signed by Fiifi Dafeamekpor. Now let's come and do some analysis. Okay, Fiifi Dafeamekpor, give me the photograph again. Mr. Fiifi Dafeamekpor has filed a suit in court. When people file a suit, you will assume that they are ready for the action. They want to go to court to find out something. So he's filed a suit in court. His suit is being heard. He says, why are you hearing my suit before you hear another person who's filed? You have filed a writ in court. You have principal interest in it. Unless, of course, he didn't have any interest and he was just playing, joking, or doing some political gymnastics or something like that. But otherwise, you have filed a matter in court. You filed a matter. The court says that the matter that you filed, I'm hearing it. You say, no, I don't want your court to hear it. I want the court to hear Richard Delaskai's own because he filed it before my own. And then in the statement, you concede that the Lord Chief Justice has the right at a discretion to file cases, to impanel judges to conduct cases. The Attorney General, who felt that this one, that Dafeamekpor matter, which is stopping ministers from doing their work, he's the Minister for Justice and Article 88. This thing that is going to stop ministers from doing their work is not correct. So he took steps to get the Supreme Court to now deal with it. Okay, so the controversy now is, what steps did the Attorney General take? Was it legal? Was it capricious? What was it? Okay, so let's go to the next one, the application. The Attorney General wrote a letter. Now, the NDC lawyers in their statement talk about abridgment of time. which is a legal process. Now let's explain the difference between the letter that is written and the abridgment of time. Abridgment of time occurs, and every lawyer knows that. Dominic Ayini must know that, and other lawyers must know that. The abridgment of time occurs when there is a date on the document. Paul Adomochi versus Dafeamekpor. Date 11th August. I have 11th August on the date. I don't like 11th August, so I bring an application to bring the time forward. That's one process. The Attorney General has repeatedly said in all the interviews that that is not the process that he succumbed himself to. That is not the process that he was occasioning. The Attorney General was not occasioning a process of abridgment of time. He has said it over and over and over and over again, that the NDC lawyers have completely misunderstood it, or perhaps are unaware of another way in which you can bring the case forward, especially in circumstances where there's actually no date fixed. In circumstances where there's no date at all fixed, this is what you do. This is what you do. You write a letter. Let's look at the letter that he wrote. Now, this letter is written on the 25th of March, 2024, and it's entitled Application for Expeditious Hearing. Roxanne Dafeamekpor versus Speaker of Parliament, blah, 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 blah. Okay, so let's look at the letter. It's Office of the Attorney General and the Ministry of Justice. Her Ladyship, the Chief Justice, is writing, the Attorney General is writing to the Chief Justice. This application, okay, what does it say? Respectfully, the Attorney General is the second defendant in the above mentioned suit, pending on the Supreme Court. The plaintiff, a citizen of Ghana, invoked the original jurisdiction of the Supreme Court on 18th. Okay, please find attached a copy of the writ. Let's move on. On 21st March, the plaintiff filed an application for an order of interlocutory injunction to restrain the Speaker of Parliament from proceeding with the vetting and approval of the names of nominees of the President submitted to Parliament until the requirement that a Minister of State shall be appointed by the President with the prayer of approval of Parliament is satisfied in respect of Honorable Henry Korte, Honorable Asensu Boache, Honorable Kojo Nkrumah, Honorable Ambrose Derry, Honorable Abdullah Abanga, who have been purportedly reassigned new ministerial and deputy ministerial offices. Please find a copy attached. This is the claim of Dafeamekpor. He actually names the ministers against whom he is filing this writ, that they cannot be reassigned without subjecting themselves to another vetting because the president said they are terminated. Let's move on. Respectfully, the Attorney General says it is pertinent to indicate that the substance of the above mentioned suit is a challenge to the power of the president to relieve ministers serving in his government of their portfolios and reassign them to different ministries. It has no bearing on the approval of persons newly nominated by the president as ministers and deputy ministers and who have been duly presented to Parliament for approval in accordance with Article 78(1) and 79(1) of the Constitution. So what the Attorney General is saying is that Dafeamekpor's rate is challenging those ministers who are being reassigned and therefore should not go for vetting. That has been the practice. You are moving from Ministry of Interior to Ministry of Defense. You don't go for vetting. Announcement is made and then you move on. Dafeamekpor is saying that given the current circumstances, that should not be. So he names the ministers. Then the Speaker says that, oh, there's an injunction against those ministers. So in fact, those who have been vetted, I will not proceed. This is what the Attorney General is saying. Let's move on and get it. Nonetheless, the pendency of this suit was advanced, that's what I was just saying, was advanced by the Speaker of Parliament as a basis for the suspension of the approval processes of persons nominated by the President as ministers and deputy ministers who have been duly presented to Parliament for prior approval. Whilst recognizing your absolute prerogative in matters bordering on the empaneling of a court to adjudicate on disputes, we humbly indicate that, this is Attorney General, it is in the overarching interest of the nation for the expeditious hearing of the plaintiff's application for an order of interlocutory injunction to restrain the Speaker of Parliament. Attorney General is saying that this matter has to be heard because it is in the interest of the nation. In the circumstances, the Attorney General says, we respectfully pray your ladyship to exercise your powers under the Constitution and the Courts Act, Act 459, to empanel the Supreme Court to hear the plaintiff's application for interlocutory injunction as expeditiously as possible. We thank you in anticipation of your cooperation, and the letter is signed by Godfrey Eboadame. This is the problem. This is the letter that creates the problem. The Attorney General felt that, look, this matter, I need it to be heard quickly. The nation needs it. So he applies to the court and says, my Lord Chief Justice, let's hear the matter. If you want Richard Delak Sky matter to be heard, please apply to the court. What kind of, I don't understand it. They are telling